Alexander Burnett, please.
Thank you and good afternoon. Now, there's been some concern that the Office of the Internal Market is going to be able to overrule decisions made by the devolved administrations. I just wonder if you're able to allay those concerns today.
I hope so, Mr. Burnett. One of the things that we do want to do is to make sure that we can work on common frameworks to uphold common standards. And to be fair to all the governments of the United Kingdom, there has been continued and energetic progress on common frameworks over the course of the last few weeks and months.
Thank you. That's very reassuring. Can I also finally ask why this office is going to be sitting within the CMA and how you propose to go about appointing people to it?
Well, again, the Competition and Markets Authority has a UK-wide brief, and it's there to ensure fair competition overall. But one of the things that we would want to do is to make sure that we work with devolved administrations and others in order to make sure that its work could command confidence.
Thank you.
Thank you, Alexander. Tom Arthur, please.
Thank you, Convener. Good afternoon. Mr. Gove, Schedule 2 lists services to which mutual recognition does not apply. One of those services is healthcare services. Can you explain to the committee why healthcare services is listed in Schedule 2, Part 1?
Yes, because we wanted to be absolutely and unambiguously clear that our NHS is not for sale.
Is that the reason why? What would the consequences be if healthcare services was not listed in Schedule 2, Part 1?
Well, again, it provides additional clarity and emphasis, underlines the importance of the shared commitment that all of us give to the NHS.
Well, that's reassuring. I appreciate that. In the bill as amended, Clause 17.2, it gives the Secretary of State power to remove entries in the table at Part 1. Why is that power in place to allow the Secretary of State, through regulations, to remove entries in Schedule 2, Part 1?
Well, the power should always be there for additions as well to be made. Ultimately, the Secretary of State is the decision maker, but it's obviously the case that decisions on this would only be taken after appropriate thought and consultation.
Okay. So healthcare services is listed within the schedule, and the bill confers a power on a Secretary of State with a statutory instrument to remove healthcare services. Was any consideration given to putting healthcare services on a permanent footing so that it could not be removed from the schedule?
Well, again, we will always listen to any fairly expressed request from any politician or any party in order to further strengthen the protections that we give to the NHS.
So would the UK government consider an amendment to this legislation to ensure that healthcare services cannot be removed from Schedule 2 via regulations?
Well, it's already the case. We believe that there is firm protection as a result of the provisions that exist within the bill, but of course we're always happy to discuss with the devolved administrations and others. But again, I should stress that there's no one in UK politics at the moment, nor should I imagine there would be ever, who would wish to undermine the basis on which the NHS is constituted and its services are provided.
Oh, I appreciate that entirely, and I very much welcome the fact that healthcare services is included within Schedule 2, because, to use your words, our healthcare services are not for sale. My only point being is that healthcare services can be removed from Schedule 2 via an affirmative instrument, but not only can it be removed via an affirmative instrument, it can be removed via the made affirmative resolution procedure as provided for in Clause 17.4. So what I want to ask Mr Gove is, why is the UK government giving itself the power to remove healthcare services from Schedule 2 Part 1 immediately after the bill is passed for up to 3 months without Parliament having a say? I'm just curious as to why that power is there. If you, like me, want to see healthcare services provided and you think there's no likelihood of anyone wanting to sell off our NHS, I have a provision in the legislation which, following your logic, would allow this to happen.
Well, it is the case, as we both recognise, that we want to make sure that the NHS is not for sale. And the reason that it's there is in order to provide that additional reassurance. It's a bit like the amendment on the minimum unit pricing for alcohol. It's putting there in capital letters what was always our intent. And one of the things that we have sought to do is, there are some voices, I know not yours, that would seek to scaremonger on this issue. And the reason it's there is in order to provide that reassurance that actually there is no impact, there could never be and will never be on our NHS.
I agree, Mr. Gove. I don't want to see anyone scaremongering. I think the way we could avoid any scaremongering is to ensure that the protection of healthcare services is not in a schedule which can be amended by the Secretaries of State. It's on the face of the protected and can only be altered through primary legislation. So I'll ask you again, will the government give consideration to an amendment to ensure that healthcare services cannot be removed from Schedule 2 via a Secretary of State using the affirmative procedure or the made affirmative procedure for the first 3 months?
Well, I take your point, Tom, and I will look at the legislation because we want to provide people with absolute reassurance on that. But of course, the legislation has been framed in a particular way in order to make sure that our internal market can operate. And one of the things that I should say is that we don't believe at all in any way in allowing our NHS to be traded away. But there are a thicket of provisions that safeguard the position of the NHS and other legislation. But I'm more than happy to discuss with you and with others any additional safeguards that may be thought to be required.
Okay, but finally, you would recognise the bill as it currently stands would allow the Secretary of State to remove healthcare services from Schedule 2 within the first 3 months of the bill being passed. So without a parliamentary vote, the Secretary of State could remove healthcare services within the first 3 months of this legislation being passed, which would, to follow your logic, allow our healthcare services to be sold off. I obviously don't believe that's going to be the case, of course, but it is a legal possibility as the bill is currently drafted, is it not, Mr. Gove?
Well, I'm glad that you acknowledge that it's not going to come to pass, because there are some people who do take that conspiracist view, but I'm reassured that you don't.
Yeah, well, it comes down to a matter of trust, but clearly when the government's pushing forward legislation which is regarded as breaking international law, trust is at a premium. But anyway, thank you, Convener. No further questions.
Okay, Jackie Bailey, please.
Thank you very much, Convener, and good afternoon, Mr. Gove. Colleagues have obviously explored with you the details about the substance of the bill, but I want to take a step back and ask about process, because I think it's fair to say that there have been a variety of views about the bill, everything from polite reservations to outright hostility. And it certainly appears that the devolved nations have serious concerns remaining. So on that basis, is there an opportunity to pause and get the consensus necessary, or are you just going to railroad the bill through?
Well, it's a very fair point, Jackie, that you make, and there have been, as you quite rightly say, a variety of different responses. We want to make sure that, and this committee hearing is part of that process, that people appreciate what is and what is not in the bill. Now, we do need to have the legislation in place by the 31st of December, because that's when the transition period ends. That's when single market rules fall away. But if there is more that the UK government can and should do in order to explain the intent behind the bill and to build support for it, then of course we will.
Let me just press you on that point, because as I read it currently, you have a number of the devolved nations likely to withhold consent for the bill as it stands. Will you therefore pause and negotiate again with them?
No, we won't pause on the implementation of the bill, but what we will seek to do is to properly and better understand any concerns. It is the case that if there are ways in which the bill can be improved, not least in the House of Lords, then we will take the opportunity to do so. The essential purpose of the bill, to make sure that we have a functioning UK internal market, is one that is shared by the Welsh Government and by the Northern Ireland Executive. Issues have been raised about aspects of the bill. We will work in good faith with those administrations to try to find an answer. But ultimately, we do need to ensure that we have a functioning statute book on January the 1st of next year.
Okay. The other thing that I think the debate around the bill illustrates is the need for perhaps new institutional architecture to make it work. And I'm thinking in particular of a disputes resolution mechanism between governments, never mind anybody else. Do you think the proposals as they stand within the bill are sufficiently robust to enable that to happen?
Well, again, it's a very good point. I'd say two things. The first thing is that in our attempt to find consensus on a way forward, we have been working with the governments on approaches towards the internal market. The Scottish Government withdrew from our internal market work strand a wee while back, and we regretted that. On your point about dispute resolution, in parallel with this bill, we're working with the Scottish Government and other devolved administrations to look again at the whole structure of intergovernmental relations. Dispute resolution is part of that. And while those conversations are ongoing, I hope it will be the case that we can find a way of having a robust dispute resolution mechanism with independent advice, which people can have confidence in.
I'm conscious of time, convener, so I'll stop there. Thank you very much.
Okay, thank you. John Mason, please.
Thanks very much, convener. I was wondering if I could ask Mr. Gove around the area of professional qualifications and specifically teachers. I mean, for quite a long time, teacher qualifications have been different in Scotland, and I think some of them are a bit worried that if there's got to be mutual recognition of professional qualifications, that anyone could come in from the rest of the UK and teach in Scotland without meeting the normal Scottish standards.
I don't believe that the bill would allow that to happen. No, I think it is the case that it has no impact on the provision of educational services. No.
But it does have impact on professional qualifications.
But it wouldn't lead to any change in the way in which Scotland would regulate its education system.
Yeah, I mean, my understanding of it was that, for example, I'm an accountant, so generally speaking, a Scottish or an English and Welsh accountant can switch over and work in either place, but that isn't currently the case for teachers.
No.
In Scotland, a teacher has to have a degree, I think, in the subject they're teaching in, which I don't think is necessarily the case in England.
Three things that I'd say. Firstly, it is the case that there are distinctions in professional qualifications. So it is the case, for example, that, as you know, by definition, Scots law is a different legal system to that in England, and English lawyers can't appear in Scots courts except after acquiring appropriate qualifications or with particular permission. And in the same way, the regulation of what happens in Scotland's schools is for Scotland's government. But sadly, it is not the case that every teacher in Scotland has a degree in the subject which they teach. Would that it were so? And one of the problems, of course, that we've seen over the course of the last 13 years is a decline in educational standards in Scotland relative to other parts of the United Kingdom. And that is a source of deep regret. But of course, there's a live debate in Scotland about how we can improve educational standards.
But, well, I suppose my final point then on that would be if theoretically, which I don't accept, there was a problem with Scottish education and we're trying to improve it, then one way of improving it would be to raise the kind of professional standard of teachers here. But would we be able to do that if that was going to exclude teachers from elsewhere?
Well, again, I think it's entirely for Scotland to regulate who can teach in Scottish schools. But one of the things that I would say is that because of the approach that the Scottish Government has taken towards inspection, towards examinations and towards the curriculum, we have less information about what's working well and not so well in Scottish schools compared to other parts of the United Kingdom. And that's why I think it's critically important that, as well as additional investment in tuition for those students who've fallen further behind, as has been put forward by Douglas Ross, that we also have more information for parents about how schools are performing so that we can learn from the best schools in Scotland and support the weaker schools in Scotland. That had, I believe, been the approach that the Scottish Government wanted to take in the past but chose not to pursue. But I agree with you. Improving the quality of education in Scotland is something that's close to all our hearts, because we want to make sure that Scottish children are well educated, and then in the United Kingdom they can take advantage of the economic opportunities the internal market provides.
Right, I'm going to a supplementary in from Angela Constance. I'm going to allow that because we need to get back to the bill and some of this extraneous nonsense that I'm hearing at the moment. Angela,
I'm sorry that you I thought they were very upfront.
Okay, thanks, convener. Indeed, back to the internal market bill, specifically clause 48. which amends the Scotland Act to explicitly reserve to Westminster, I quote, regulation of the provision of subsidies which are or may be distortive or unharmful by a public authority to persons supplying goods or services in the course of a business. I'm talking about state aid here. And the Scottish Trade Union Congress said that the bill does not detail what these regulations might be or what implications there may be for devolved decision making and the devolved settlement. Effectively, it reserves state aid to Westminster, despite this not currently being reserved in the Scotland Act. It's quite hard to see how this is not a power grab by the UK government, Mr Gove, is it not?
No, it's very easy to see how this isn't a power grab at all. At the moment, the state aid rules are governed by EU law. The EU is, as we know, in the negotiations between the UK government and the EU at the moment, very interested in state aid because it's been able to control how state aid is allocated by its member states. It is the case that when it comes to making sure that any government approach towards state aid complies with WTO and other international rules, that it's the government which deals with international relations which is responsible for that. International relations is a reserved matter, so it's only right that we set the groundwork, but it's also that within that, the groundwork having been set, the Scottish Government would retain the power within that overall framework to provide state aid and other support for enterprises in Scotland as appropriate. But as I say, it will be the case that we will be taking on the responsibility that the EU has hitherto organised. But of course, there'll be more money to support Scotland outside the European Union, because, as you know, we currently send some £20 billion or so to the EU every year. We only get about £10 billion of that back. Outside the EU, we'll be able to spend that money for ourselves. We'll be able to spend it on the people's priorities, and that means that we'll also be able to support the Scottish Government in supporting those economic enterprises that are crucial to Scotland's economic future and well-being. So it's a win-win.
Okay, we've reached 4:30. I thank Mr Gove for his evidence today.